Breaking news out of New York, a major win, not only for the Second Amendment's right to keep and bear arms, but also for the First Amendment's religious freedom clauses. They do go together in many respects, and they're victorious tonight. Let me tell you why in a second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms and help us get to 100,000 subscribers. It'll help us with the social media algorithms. Okay, major breaking news out of Buffalo, New York, and I'm not talking about the snowstorm, by the way. Judge Sinatra, a federal district court judge in the Western District of New York, entered a major 36-page decision in favor of your right to keep and bear arms in a case called Spencer versus Negrelli. Not only did he rule that New York's new law that bans firearms in churches violates the Second Amendment's right to keep and bear arms, he also points out that the ban on guns in churches and places of worship also violates the First Amendment's religious clauses, not just the right to exercise your religion freely, but also the Establishment Clause, which prevents the government from basically getting micromanaging the details of churches and other religious services and the like. Bottom line is, Judge Sinatra concluded this is a lawsuit brought by a minister who's licensed in New York to conceal carry firearms. He had been carrying guns for multiple years in the church to protect his congregants. In fact, he specifically said and swore to that he felt he had a Christian obligation to protect his flock, to protect his congregants, to protect his church. He thought he had not just a moral duty, but a religious duty and a Christian duty to do so. And he said that once the state of New York banned him from carrying guns, which prevented him from carrying a gun to protect his flock, his congregation, going forward, he thought not only did that violate his right to keep and bear arms under the Second Amendment, it also violated his right to exercise his religion freely under the First Amendment, as well as the interference with the operations of his church in violation of the First Amendment's Establishment Clause, which bars the establishment of some sort of government-sanctioned religion. So basically, Judge Sinatra entered an order today saying that indeed, not only that New York's law violate the Second Amendment's right to keep and bear arms, because there is no historical tradition going back to 1791 that allows the government to ban firearms in places of worship such as churches. He also goes on and actually engages in analysis under long-standing Supreme Court precedent involving the First Amendment. He specifically goes through and says that the critical thing about the Free Exercise of Religion Clause is this, that government may not burden churches and places of worship in a way they do not burden other places. And he said, Judge Sinatra said, that because churches were not allowed to have guns, that could not have guns in places of worship, but in contrast, other non-churches, non-places of worship in New York had the right to determine whether or not to have guns in their private property. That violated the First Amendment because it unduly burdened the right to practice one's religion in a church, because they put governmental restrictions and laws on that practice that they do not apply equally to other private sector, non-denominational, non-religious parts of the state of New York. And because of that burden, that violated the First Amendment's free exercise of religion clauses. And the only way the government could justify that is through strict scrutiny, which is totally unacceptable in the Second Amendment context. But those tiers of scrutinies we inherited because of liberal judicial activism over the last 60 years applying to First Amendment. So he did apply longstanding Supreme Court precedent and did strict scrutiny analysis and pointed out that there was no basis, there's no way on earth that the government could show that there was some special benefit to banning guns in churches, but not in other parts of the state of New York, and therefore unduly and improperly and unfairly burden churches with gun-free zones, which they did not do with the non-religious parts of the state of New York. He also went on to say that this law likewise violated the Establishment Clause because, yet again, it was government micromanaging the administration of church practices, which is generally speaking not allowed absent some compelling state interest, which Judge Sinatra specifically said the state simply could not do. And he went on and said that he is enjoining the state from enforcing these laws as applied to, as it relates to gun bans in these churches. However, he did acknowledge that the Second Circuit Court of Appeals had certain aspects of a stay in place. So basically he's modified, although he's found all of these laws, these gun-free zones, when it comes to churches and synagogues and the like, to be unconstitutional. He does modify the nature of his remedy in a way that's consistent with the stay order from the Second Circuit Court of Appeals. And I believe what he said is churches can right now designate certain people that are eligible and authorized to protect their churches and places of worship with firearms, and those people are allowed to carry guns, and those gun bans will not be enforced against those people. I believe the state of New York has agreed to that, and as a consequence, even though Judge Sinatra has found these laws to be unconstitutional, he narrowed the scope of the remedy for the moment because of a deal that apparently was cut between the state of New York and the plaintiffs in this case of Spencer versus Negrelli. Again, major win today, not just for the Second Amendment, but for the First Amendment. We'll be tracking this case. I'm sure it will go to the Second Circuit Court of Appeals, which, as you know, is also part of what's going on in the Second Circuit. It's before the U.S. Supreme Court, so we'll obviously keep track of all this. But for today, it's good news out of Buffalo, New York, and not just because the snow is going away, but also because the First Amendment and the Second Amendment have been vindicated when it comes to our right to keep and bear arms. Okay, hope you learned something. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.